Hi, I'm Margie Levine, Assistant Counsel with the Ethics Law and Policy Branch at the Office of Government Ethics. We're back with Part 2 of OGE's training on seeking and negotiating employment. Next slide. I'll continue providing an overview of the Subpart F requirements, including the SOC Act notification requirements, and we'll talk about how Subpart F's role as offense helps to prevent employees from violating the Criminal Conflicts of Interest statute, and ethics officials' equally important role in providing advice to employees about seeking employment as early and as often as you can. Next slide. We ended Part 1 of this training talking about when an employee is considered seeking employment, and thus when the Subpart F recusal starts, and when the employee is no longer considered seeking employment and no longer needs to recuse. And it's those unsolicited communications by the employee, the prospective employer, or an intermediary regarding a job opportunity that Subpart F says starts the seeking employment and triggers the recusal requirement. A major ethics concern about these one-sided, unsolicited communications is that they can quickly turn into bilateral, back-and-forth conversation about the job opportunity that meets the definition of negotiating for employment. Next slide. Negotiating for employment is defined in Subpart F as discussion or communication with another person or such person's agent or intermediary, mutually conducted with a view toward reaching an agreement regarding possible employment with that person. The term negotiating is not limited to discussions of specific terms and conditions of employment in a specific position. Now, not every two-way conversation is going to meet the definition of negotiating for employment. For example, going for an informational interview where an employee is just learning about what a company does with no discussion of hiring the employee or what each side needs for moving forward with employment would not be negotiating for employment. And there's an example in Subpart F that confirms this view that an informational interview is not seeking or negotiating employment. Next slide. But where the conversation progresses to both sides showing interest in the employee coming on board and a discussion of some of the terms or qualifications of employment, the employee is likely meeting the definition of negotiating employment, whether the official job interview has happened or not. And if the employee meets the definition of negotiating for employment, they're now in criminal statute territory. They're in 208 land, and they could face criminal consequences for failing to recuse for matters affecting the financial interests of their prospective employer. Next slide. And for your reference, the relevant part of 208 regarding negotiating for employment is on this slide. 208 prohibits employees from participating in matters that will affect their own financial interests, as well as the financial interests of others that are imputed to them, including a prospective employer with whom you are negotiating employment or with whom you have an arrangement concerning prospective employment. Next slide. And as I mentioned, once an employee is seeking employment, it can quickly turn into negotiating for employment. For example, let's say a non-federal employer views a federal employee's professional profile on LinkedIn or another website, and then messages the employee to say, our IT division is hiring. Please let us know if you're interested. And the employee responds with a question like, what kind of work would the job involve? The employee is now seeking employment by giving a response other than rejection. However, if the prospective employer then responds with a description of duties, And there's additional back and forth about what either side needs in terms of qualifications or other employment terms, or ways the employee could remedy one of the missing qualifications. The employee would likely be negotiating for employment at that point, even if they haven't covered all of the terms of employment and they haven't actually sat down for a formal job interview yet. You'll find a couple of examples in subpart F, right below the definition of seeking and negotiating employment, that aim to clarify when seeking becomes negotiating. But in a real-life job search, it's not always easy to tell when the conversation moves from just the seeking employment stage to the negotiating stage. And so employees may unknowingly enter criminal statute territory in a matter of words. And that's really the whole point of the subpart F recusal, to address this major ethics issue of seeking becoming negotiating in a matter of words. What does subpart F do? It imposes the same recusal requirement that 208 imposes for negotiation and arrangements for employment, but earlier in the employee's job search process. The recusal starts at the seeking stage. And for that reason, the subpart F recusal requirement is like a fence, designed to prevent employees from veering into 208 land and violating 208. Next slide. There are a few parts of subpart F summarized on this slide that may impact an employee's recusal requirement under subpart F, but they don't come up that often, so I'll mention them only briefly for your awareness. There is a limited exception to the subpart F recusal requirement, which can be found in 2635-604A2, and according to that exception, where an employee participates in policy or regulatory matters, or other matters of general applicability that would affect the prospective employer's financial interests, the employee may participate in those matters if the employee's only communication with the prospective employer has been to submit a resume or job proposal, and the prospective employer has not responded with an indication of interest in employment discussions. Because this is a limited exception, meaning it doesn't apply to specific party matters, and it would only apply where an employee works on particular matters of general applicability, and they haven't heard back from the prospective employer after sending the resume, it's not going to come up often, and it's not something to focus on when you train and advise employees. What should be emphasized in your advice is that employees come to you as soon as they're seeking employment, or even earlier, as we discussed in part 1, when they're considering starting a job search. And that way, you can advise them on whether they've triggered the subpart F recusal requirement. And then, as you learn more about their situation, it's possible that their facts meet this exception. Regarding the second bullet point on the slide, subpart F provides agencies with some discretion regarding how the recusal requirement plays out in two specific situations. First, if an employee is materially impaired from doing their job as a result of the subpart F recusal requirement, the agency can determine that the employee needs to take annual leave or leave without pay or get reassigned. And you can learn more about this area of discretion in section 2635-604D. And the second situation is where the employee is no longer negotiating for employment because the job offer wasn't ultimately extended, or for some reason the negotiations started but fell through. In that situation, the agency has the discretion to extend the subpart F recusal to whatever period of time makes sense in that situation. And to learn more about that area of discretion, you can look at section 2635-606. Finally, subpart F has a section on waivers and authorizations, which, if granted, would waive or authorize the employee to participate in matters affecting the prospective employer. And that section on waivers and authorizations is 2635-605 if you want to learn more. I would note that the authorization would only be possible when seeking employment, not when negotiating employment. And the employee would need to meet the authorization process and standards of 2635-502D. And a 208 waiver would only be possible for negotiating, not seeking employment, and would have to meet the waiver standards of 208B1 or B3. Next slide. The Stock Act requirements are the second component of Subpart F. We talked at length about the first component of Subpart F, the recusal requirement. And the Stock Act stands for the Stop Trading on Congressional Knowledge Act, and it was enacted in 2012 and modified in 2013. Among other things, it imposes 2 notification requirements on employees who file a public financial disclosure report, OGE Form 278, and who are negotiating or have an agreement for future employment or compensation with a non-federal entity. And when OGE amended Subpart F in 2016, it added these 2 Stock Act notification requirements to Subpart F. And the 2 notification requirements are on this slide, and they provide that anyone who is a public 278 filer and who is negotiating or has an agreement for future employment or compensation with a non-federal entity must notify their ethics official of the negotiation or agreement within 3 business days of the start of the negotiation or agreement. And the public filer must also notify their ethics officials of their recusal requirement when there's a conflict of interest or appearance of a conflict with a non-federal entity identified in the notification. The notification must be in writing and signed by the public filer, and it must include the name of the prospective non-federal employer or employers, the date on which the negotiation or agreement started, and for further information on these Stock Act requirements, you can refer to 2 legal advisories that OGE issued, LA 1201 and LA 1306. And those legal advisories suggest a format for the required notifications that agencies can use. Subpart F requires that these notifications be sent to the DAO or another ethics official. So note that the public filer does not need to send this notification to his supervisor, nor is the ethics official required to send this notification to the employee supervisor. That said, and this is true of the Subpart F recusal requirement, the public filer must do whatever is necessary to carry out the recusal if they have a recusal. And practically speaking, notifying the supervisor or colleagues may be necessary to carry out the recusal. Next slide. I want to highlight what I think are the most noteworthy aspects of the Stock Act notification requirements, particularly in terms of how they differ from the Subpart F recusal requirement. I have also provided you with a chart as a handout and on the next slide that compares side by side these aspects of the Stock Act requirements and the Subpart F recusal requirement. So feel free to look at that chart now as I go through this slide because this slide covers the same material as the chart. So we know that the Subpart F recusal requires employees to recuse immediately from matters affecting the prospective non-federal employer once you are seeking employment with them. The Stock Act notification requirements are in some ways narrower in their application than the Subpart F recusal. First, the Stock Act requirements apply only to public filers, and that does include political and career public filers, whereas the seeking employment recusal applies to all executive branch employees, regardless of their filing status. The Stock Act requirements and the Subpart F recusal both apply to non-federal entities, so they're the same in that respect, but the notification requirements do not get triggered by seeking employment actions. Rather, They get triggered by only negotiations or agreements for employment. And this is the most striking difference between the Stock Act requirements and the Subpart F recusal. The notification requirements apply only to negotiations or agreements for future employment or compensation for personal services. And here, future means starting after the employee leaves government service. In other words, the job that the employee is negotiating for needs to start after the employee's federal employment ends, or the compensated services have to be rendered entirely after termination of federal employment in order for these notification requirements to be triggered. On the other hand, you'll recall that the seeking employment recusal applies to both future post-government employment and employment that happens at the same time as the employee's federal employment. So if a public filer is negotiating with a local university to teach a class, and the public filer will do this teaching concurrently with their government job, they don't have to file these Stock Act notifications. But note, they would still be subject to the Subpart F recusal requirement and 208, and they might also be subject to outside earned income limitations or the outside earned income ban and limitations on teaching, speaking, and writing in 807 of the Standards of Conduct, among other rules. And one of the legal advisories I mentioned, LA 1306, discusses some of these other ethics restrictions further. You'll also notice that the Stock Act requirements apply to future employment or compensation. And you may recall that the Subpart F recusal and that related definition of employment don't mention compensation. What the added reference to compensation in the Stock Act rules does is it signals to public filers that if you enter into any sort of agreement to provide services to someone after you end your government employment, and your services will be compensated, even if you don't consider the person for whom you'll provide the services to be your employer, maybe they're more of a client, you'll still have to file the Stock Act notifications. For example, let's say you're going to open your own event planning business and you enter into an agreement to put on an event for a company after you leave government. And you consider the company to be a client, so you don't view this to be an arrangement for employment. But that's an agreement for compensation to provide services after you leave the government. So you'd have to file the Stock Act notifications. And the Subpart F recusal requirement would also apply in that scenario as soon as you start reaching out to your event planning clients for potential work, if the client's financial interests would be affected by your government work. Finally, regarding timing of the Stock Act notification requirements, the public filer technically has 3 business days from the start of the negotiation or agreement for future employment or compensation to file the notifications. And the filer must file the recusal statement whenever they believe there is a conflict or appearance of a conflict. However, when OGE added the Stock Act requirements to Subpart F in 2016, OGE included language in the regulation allowing and encouraging public filers to get the Stock Act notice in as early as possible and prior to starting to negotiate for employment. So the filer can file the negotiation notice before they start negotiating, and they can file the recusal statement before they have a conflict or appearance of a conflict with a non-federal entity. They're not required to file this advance notification, but they can. And that advance notification continues to satisfy the Stock Act notification requirements once negotiations actually begin or an agreement for employment is reached. Employees don't need to file a subsequent notification, provided that the non-federal entity's name is listed in the advance notification and the employee gave an estimated date of negotiation. If you think about it, these advance notification provisions in the Stock Act section of Subpart F are well aligned with the other part of Subpart F, the seeking employment recusal requirement, because both parts push for early completion of the requirement. You have to recuse as soon as you start seeking employment, before the negotiation stage. And you're encouraged to file the Stock Act notifications earlier than the negotiation stage to help prevent employees from violating 208, the Criminal Conflicts of Interest statute, and to prevent noncompliance with the Stock Act. And so in that sense, the fence runs through all of Subpart F, both the recusal component and the Stock Act section. And you, as ethics officials, play a key role in building and supporting that preventative, protective fence by giving advice and training about Subpart F early and often, particularly because, as we discussed, the seeking employment situation where an employee or prospective employer makes that unsolicited communication about a job can quickly, in a few words, turn into a two-party meeting of the minds to bringing them on board conversation that crosses to the other side of the fence and triggers the criminal statute. And your role in counseling employees to come to you as early as possible in their job search for guidance and to recuse before the negotiation stage and to get their notifications in well before negotiating is critical. Next slide. This is the chart I mentioned that highlights the main differences between the Subpart F recusal requirement and the Stock Act notification requirements. Next slide. And this concludes our two-part review of Subpart F and its two components, the recusal requirement and the Stock Act notification requirements. Should you have any questions about Subpart F, please feel free to get in touch with me or with your agency's OGE desk officer. Thank you for watching this training.